Good morning, Council. Today's date is July 19th. The court's going to hear two arguments this morning by Zoom. As you can see, today's panel is Judge Hensel, Judge Callahan, and myself. And we will begin with case number 22CA0004-M, Weaver versus Ohio Farmers Insurance. Each of you will have 15 minutes to present your oral argument. The appellant may reserve up to 5 minutes for rebuttal. Attorney Conway, if you're going to reserve, let me know and I'll keep track of that time for you.
Yeah, I'd like to reserve 5 minutes for rebuttal, Your Honor.
All right, and I'll let you know as you get close to that time. I may interrupt you, but that way you'll at least know when your rebuttal time is.
Of course.
The arguments, as you know, are recorded and posted on the court's YouTube channel, so we ask that you keep your voice up. And we've read the briefs and we're prepared to proceed if you are. As I said, I'll let you know as you get close to that 5 minute mark. Go ahead, Attorney Conway.
Thank you, Your Honor. Let the record reflect I am Mike Conway. I'm the appellant's counsel representing John Weaver. He has brought a lawsuit against Farmers Insurance Company, AKA Westfield Insurance, where he used to work between 2012 and January 2020. And his job was the learning development operations leader. And what happened was in January of 2019, the company, through a manager named Lori Gable, who was my client's boss, hired a female employee to take my client's place, in effect, through an act of pre-selection, and gave her the job of learning development leader. The only difference between the job that was given to Lori, to Connie Fry, who was my client's replacement, was the word operations was taken out of her job title. If you look at a comparison of job descriptions for Weaver and Fry, the MSJ Exhibits 1-19 and Exhibit 20, in spite of the fancy MBA talk in those exhibits, the jobs basically are the same thing. It's running the education department at Westfield, make sure employees are trained and have the resources they need to advance their career education. And what's interesting is that Ms. Fry was hired without a competitive job interview in secret. My client wasn't informed that she was going to be taking his place until it happened. Prior to that, she was basically a college recruiter for Westfield. And after she was hired, the company then said, we're now going to have a reduction in force. And that the supervisor, Lori Gable, said, it's because, we got to save money. The problem is she was following an affirmative action policy that the company issued that was meant to promote women over men and increase the number of women over men dramatically, and my client obviously fell victim of this. Those are the circumstances a jury can work with to infer reverse sex discrimination. And the fact of the matter is that we asked for the affirmative action policy after the other side moved for summary judgment, saying we didn't have any evidence, and they wouldn't hand it over. We moved to compel, and the court denied it. That being said, we did have enough information to draw the inference that the company's policy was to increase women managers over male managers, and my client was let go. There's never been any evidence the company lost a dime or made it or saved any money through its reduction in force. And in fact, after Connie Fry retired a year later in 2021, she was replaced by a new hire who had a virtually identical job description she had, and there was another open position created, and all these were in the Westfield University, dealing with educating employees and operating the learning process, making sure they had the right equipment, supplies, all these things they needed. The defendant employer will say, we changed the structure of the organization, went to some hybrid management plan. The fact of the matter is, all they did was turn a spider diagram, management diagram on its side and say that's the new way. My client still would have had a job had he not been replaced by Connie Fry, who was less qualified than he was to do the same job he was doing before it was taken from him and given to her. The defendant employer will say, well, a woman did not make the decision to replace your client. That's not correct. Chris Paterakis, who was the HR manager, relied on the recommendation from Lori Gable to replace my client with Connie Fry. And the defendant employer will say, well, you can't question our business judgment. My response to that is, oh, yes, we can. Because business judgment in and of itself isn't a defense to anything. It can be tested. And in this case, the circumstances show that the employer is an unusual employer who has a policy promoting females to discriminate against the male. These kinds of facts show circumstances evidencing reverse sex discrimination under the plaintiff's first and third causes of action. We're not pursuing the second on appeal. Our theory is that we either have a case for straight out reverse sex discrimination, or we have a case for reverse sex discrimination in the context that there's reduction in force and my client wasn't given consideration to remain in his employment when the RAF was affected. Instead, he was taken and room was made for Connie Fry. And when the question on my client's qualifications came up, they admitted he was qualified to continue his employment. So we believe all these facts, again, show background circumstances showing that Westfield is the unusual employer who discriminated against the majority in this case pursuant to its own corporate policy. This isn't a case about misogyny or anything else. My client was fired in midlife from a career level position, and he has a family to support like anybody else, and he has a right to fight for his job. And the defendant employer, the appellee, cannot advance its affirmative action policy by engaging in reverse sex discrimination. They may choose to hire more women, and that's fine, but they can't fire a male employee to make way for a woman who's lesser qualified just for the sake of saying this is our affirmative action policy. And that was never their defense anyway. They've never said that our affirmative action policy is why we did anything. It was all about RAF to save money. Well, you can't say that if you replace my client. You can't say that after the replacement goes, you hire another woman to take her place and create another job. Matter of fact, after the RAF, there was a net 9-to-1 women to men ratio in Westfield University. So again, we've got enough factual evidence here to raise circumstances that should justify a jury trial. It was reversible error for the trial court to dismiss this case on summary judgment. It was also reversible error for the court not to grant our motion to compel discovery to get the affirmative action policy when the other side's saying we don't have any evidence, and then said we don't, in their discovery response, that we don't have what you're looking for in terms of affirmative action policy. We don't have quotas. Well, they have quotas. The exhibits we have put into evidence show that the appellee employer was seeking since 2017 to change the ratio, the makeup of women to men who were in management at Westfield, and they wanted to keep raising the quota. And they'll deny there's a quota system, but I don't know what you call it when you say we're going to have a certain percentage of people here of a certain kind and not so much of the other kind. That is, in fact, a quota system. So for these reasons, if there's no questions, I respectfully request that this case be reversed and sent back to the Court of Common Pleas for a jury trial, and also respectfully request that the court be ordered to consider the motion to compel discovery. It was an abuse of discretion to not do so, and its dispositive order summarily dismissing the case and summarily overruling all motions. Thank you.
All right, thank you, Attorney Conway. Let me check with my colleagues here, see if there's any questions. Judge Hensel? No. Judge Callahan? No. All right, thank you. You'll have a full 5 minutes for your rebuttal.
Thank you, Your Honor.
Attorney Adinolfi, you've got 15 minutes.
Thank you very much, Your Honor. May it please the court. My name is Karen Adinolfi, and I represent the appellee here, Ohio Farmers Insurance Company. You can't see him, but I also have Paul Jackson, my co-counsel, in the room here with me. Not sure where to start after Mr. Conway's presentation, but I'll start with this. There's no genuine issue of material fact as to the two employment actions that Mr. Weaver takes issue with here. Second, the court did not abuse its discretion when it denied Mr. Weaver's belated motion to compel. I want to turn first to the summary judgment issue and a couple of corrections as to Mr. Conway's argument. Connie Fry never took John Weaver's position. It's clearly set forth in the briefing. The Westfield University function had two leaders, Ms. Fry and Mr. Weaver. They were peers. Ms. Fry also had a recruiting function, which in, I'm going to say late 2018, was actually removed from her and reassigned to someone else in the department. She had additional capacity. Lori Gable, the supervisor at that point of both Ms. Fry and Mr. Weaver, was taking on additional duties and was stretched very thin. And so the decision was made to allow Ms. Gable to step away from the direct supervision of the Westfield University function that Ms. Fry and Mr. Weaver worked in. Ms. Fry had been with Westfield for decades longer than Mr. Weaver. The company had determined that she had better supervisory skills than Mr. Weaver did. She had the capacity to take on the overall supervision of that section. And these were legitimate, non-discriminatory reasons for Westfield to give Ms. Fry that position. Again, Mr. Weaver doesn't get to say, I'm more qualified and therefore it's discrimination if you didn't give that position to me. His subjective opinion doesn't matter in this. There's no requirement that interviews or posting or applications take place. This was a minor reorganization, and the Human Resources Department, specifically Ms. Gable and Mr. Paterakis, decided that Ms. Fry was the better one for the position. Mr. Weaver suffered no adverse employment action. His job didn't change, except there was one function added to him. He received the same salary, same title. Interestingly, Ms. Fry did not receive any increase in compensation for her taking on additional duties. So again, all Mr. Weaver has is his subjective opinion that he was the better candidate for that newly created position. That's not Rule 56 evidence. Ms. Fry had been in the Westfield University function for some time. She was perfectly qualified to take that position, and in fact had been with the company much, much longer than Mr. Weaver had. And again, all Mr. Weaver has proffered here is his opinion, his articulation of what he believes the qualifications should have been. His opinions, or his attorney's opinions, as to the job descriptions and what they say. If you recall in the brief, there's a chart where it quotes from the job description and then says Weaver says, and then his interpretation of that. That's not Rule 56 evidence. As to the layoff, the reduction of force in 2020, whereby Mr. Weaver was separated from the company, it has to be remembered that his entire department, 2 men and 6 women, hardly the actions of a company trying to keep women, was laid off. There was no picking and choosing. There was no dispute as to the underlying reason for the layoff. Mr. Weaver's burden was to show that our proffered reason, Ohio Farmers' proffered reason, was pretextual. He didn't do that. He didn't dive into how much was saved or whether there were savings. That's not Ohio Farmers' burden to show. That's his burden to show. He didn't do such a thing. He didn't dispute below or before this court, except to say it doesn't make any sense or it's not worthy of credence. Again, not Rule 56 evidence. Again, there were legitimate non-discriminatory reasons for that RIF being undertaken. a reduction in expenses, the elimination of the portion of Westfield University where they did departmental specific training. And they returned those training functions to the department, or the plan was to either do that or outsource them to third parties. Those functions are no longer being performed at Westfield. What Mr. Conway, I believe, was referring to was the hiring of a woman named Tonya Suber about 6 or 7 months after the reduction in force. There was still a training component in the HR department. It was company-wide training. It was training that everybody would take rather than the specialized training they had done before. They needed somebody to oversee that. That position was posted. Mr. Weaver never applied for it, so we don't have any kind of evidence as to whether he would have gotten that or not. So he doesn't really have the standing at this point to challenge that because, again, he did not apply for it. It's not an issue of questioning business judgment. Business judgment is a powerful defense. It's not infallible, but Mr. Weaver hasn't done that. All he has done is point to, as background circumstances, Westfield or Ohio Farmers DEI and affirmative action plans. And what he has said is those plans require or dictate the firing of males to replace with females. And it does no such thing. In fact, I believe one of the documents that Mr. Weaver had proffered actually said that this plan does not require the termination of males to be replaced by females. It doesn't. That's not what an affirmative action plan is. And you have to remember again that this was a RIF. Everyone in that group, except for Ms. Fry at that time, her position was slated for elimination, but she did stay on to wind down the Westfield University operations that were being eliminated. But everybody, there was no picking and choosing. 6 women, 2 men were downsized. The affirmative action plan had nothing to do with that. And again, there's no Rule 56 evidence that it did have anything to do with it. And in any event, any affirmative action plan or DEI initiative does not require terminating, for instance, males to replace them with females. It's an aspirational document. It's an examination of the relevant labor pool and seeing what steps can be taken to ensure equal access to opportunity. For instance, things like promulgating policies that would attract men. I'm not sure what those would be, but that's one of the things if they were looking to attract women or attract men, that's one of the things that an affirmative action plan can do. There are no quotas, and Mr. Conway knows that. There are no quotas. It's aspirational hiring. It says, for instance, in the population of the insurance or the general labor pool of people who are qualified to work in insurance, these are the percentages. We fall well below that for females, for people of color, LGBTQ. And so, again, perhaps we are not doing enough to solve that imbalance. Are we not retaining them? Do we have policies that prohibit people from wanting to stay here, from wanting to interview with us? That's what an affirmative action plan is. And frankly, to hold that an affirmative action plan or DEI initiative would constitute these background circumstances for a reverse sex discrimination claim, frankly, that would just cause companies to be extraordinarily reluctant to promulgate these policies. With respect, sort of dovetailing into the argument about the motion to compel, Mr. Weaver had 2 cases. This was a refiled case. He had 2 cases in multiple years to seek to compel production of affirmative action plans and DEI documents. And instead, he waited until after he filed his brief in opposition to Ohio Farmers' motion for summary judgment. In that motion, he didn't make any mention that the documents and information needed were needed to oppose the motion for summary judgment. And again, I don't know that he could have because he had already filed his opposition. In failing to make that mention, however, he's waived that assignment of error. He does not get to now claim that he was prevented from having discovery in order to oppose Ohio Farmers' motion for summary judgment. He has said that Ohio Farmers has withheld that information. Ohio Farmers simply objected on the basis of relevance. And again, Mr. Weaver's remedy for that was to file the motion to compel. Unfortunately, he did it too late, and he waived that argument here. So, and again, I would note that in Mr. Weaver's reply brief, my recollection is he does not even address the issue of the waiver argument that Ohio Farmers has raised. So, and in fact, he's waived that here as well. You know, and just to sum up, no Rule 56 evidence was put forth that Mr. Weaver's sex had anything to do with the decision to put Connie Fry in the position that she was, or the decision to undertake the reduction in force. Mr. Weaver makes much of the statistic that after the reduction in force, it was a 9-to-1 ratio of women to men. That's not unusual in human resources departments. If you look at labor statistics for the human resources field, it usually hovers around 70 to 73% female. So, you know, again, that's perfectly in line with what Westfield was left with. And again, the issue with respect to job descriptions and who was hired after the reduction in force took place really doesn't have anything to do with this, because Lori Gable testified there was a different position, it was a different role, had different responsibilities. And Mr. Weaver didn't avail himself of the opportunity, if he thought he was qualified, to apply for that position and compete for it. Going back to Connie Fry's placement in the position, it was not done in secret. Yeah, it wasn't posted. It was really just an administrative move. It was announced. It was not concealed or anything like that. And the reduction in force, there is no evidence in the record whatsoever that Ohio Farmers was following its affirmative action plan when it eliminated Mr. Weaver and 7 other people's jobs. Absolutely no evidence whatsoever. And as to the issue of quotas, I would just raise the issue that there aren't the affirmative action plans are not permitted to have quotas, and Ohio Farmers, there's no evidence that it did. It has goals that saying, you know, we have, you know, in our overall, say, executive leadership, we should have more females than we do. Why don't we have more females? Are we not recruiting properly? Do we have some barrier to that? But the affirmative action plan did nothing with respect to generating or causing or stamping with approval the reduction in force. And again, there's no Rule 56 evidence in that with respect to that issue. I would note that we had also filed a motion to strike in this particular appeal with respect to 2 issues that Mr. Weaver raised for the first time. One, he raises the cat's paw theory for the first time in his reply brief to this court, and some issues with respect to Lori Gable's testimony. He failed to raise those, and in fact admit so in his brief, failed to raise those at the trial court. So unless there are no further questions, I would thank the court for its attention, and we would have Ohio Farmers would respectfully request that this court affirm the decision of the Medina County Court of Common Pleas. Thanks so much.
Thank you, Attorney Adinolfi. Questions, Judge Hensel or Judge Callahan? Very good. All right, you have 5 minutes for rebuttal, Attorney Conway. You're on mute, don't forget.
Thank you, Your Honor. Can you hear me?
Yes.
All right. First of all, one of the issues opposing counsel raised was whether or not my client, John Weaver, was qualified to get the position that was given to Connie Fry. I don't know how they can raise an argument saying he wasn't as qualified because they never interviewed him. As a matter of fact, Gable claimed she didn't know what his qualifications were. Matter of fact, they didn't let anybody know that Fry was going to get my client's job till it happened. He didn't have a chance to challenge them on his qualifications. So they can't take the position my client wasn't qualified because they said they didn't know what his qualifications were because they didn't want to know what they were. They didn't investigate anything. That's evidence that goes against their credibility on that issue. The other side talks about their affirmative action policy, and they explain it in great detail about why they think it's not an issue that helps the plaintiff appellant in this case. The problem is they insisted that we not discuss the affirmative action policy. Matter of fact, they opposed my motion to compel its production. And as far as they're claiming, we had all kinds of chances to get it. First of all, we refiled this case over a discovery and timing issue, and we are not to be prejudiced by that refiling, according to Ohio Supreme Court case precedent that I put in my 41A notice. I think it was Lawrence versus Industrial Insurers. The Ohio Supreme Court said that a trial court cannot allow any prejudice to flow from a first voluntarily dismissal and refiling. And what they want this court to do is let prejudice flow. So that's a problem. Another issue that they talked about was whether or not my client can explain his own job description, saying that's subjective evidence. It's not subjective evidence. We have job descriptions we put into the record during the appellate brief, 1-19 and 20. They can be compared, and also the new job given to Tanya Suber, that when you compare those three job descriptions, it's basically all the same job, and a reasonable jury can infer that. And as far as, today they say it was a, quote, minor reorganization. Well, that's a good one. I never heard minor reorganization used in this case before until right now. The fact of the matter is they're watering down their own adverse action by saying it doesn't mean it's not as bad as we say it is. No, it is bad. And they, on MSJ, they didn't get into that minor reorganization. They didn't prove they saved any money. They didn't prove they even had any planning documents. Matter of fact, the motion for summary judgment didn't reach most of the issues they're arguing on an appellee response this morning. The fact of the matter is my client is certainly qualified to explain his own job description, and he's certainly qualified being a former executive at Westfield to talk about what the other ones mean. That is certainly competent testimony. As far as pretext, they say we didn't challenge that on motion for summary judgment. The fact of the matter is if we didn't challenge something, it's because they didn't raise it. We're only required to respond to the issues they raised on their motion, and my recollection is there was only two. One was their business judgment, and they just basically said we can do whatever we want to. That's not business judgment that withstands scrutiny. When you've got this pile of evidence showing that my client gave his job to Connie Fry involuntarily, and then he was eliminated, and then after that, and after Fry got the job, they had a reduction in force, which means she was pre-selected. And they didn't want anybody to find out about it. She even had to write her own job description with the help of Lori Gable. The job didn't even have a job description. There was no competitive interviews. And Patarakis said it didn't even have a job title. They wanted to save Fry, who retired a year later. And as far as my client, they say he waived his rights by not applying for the job Suber got. Fact is, he didn't know it existed until we filed this lawsuit. They say he was laid off, but they never recalled him. They never said, hey, John, there's a job here, come on back to work. They didn't do that. So this isn't a situation we waived anything. They're playing a shell game with these job descriptions, and a reasonable juror could see right through that.
Attorney Conway, with that, your time has expired.
Oh, sorry, Judge, I have so much more to talk about.
Well, I want to thank you both on behalf of Judge Callahan and Judge Hensel for your arguments today. We'll take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you each a copy of the decision on the day it's released, and you can keep an eye out at the Ohio Supreme Court website. Thank you both again for the arguments, and we'll move on to our next argument.